on navigating the Fair Housing Act. That's what this FFHA means. This is an issue, like Jeff mentioned, that can be a little bit polarizing, but we'll get through it, and maybe you'll walk out of here with a little bit better understanding of what's actually required of your community, what the association's allowed to do, what you have to do, and what you really can't do. So just by way of a brief clarification, thank you to Jeff for the introduction. Again, my name's Alan Schwartzide. I'm the managing partner of our Orlando office. K-Bender Rembam has offices in Pompano Beach, which is our main office, Palm Beach Gardens, as well as Tampa, and in Miami by appointment. We are 20 lawyers, all practicing in the area of community association law. 8 of the attorneys within our firm are board certified in this area of law. We have another one that's board certified in construction as well. And several of us are also circuit and county court mediators involving me, including me. And we are happy to present this seminar for your education. To clarify, if you hear anything today, it's not necessarily legal advice. We don't want to be answering questions that are specific to your community and specific to an individual matter. And the reason for that, so in other words, keep your questions very generic, because you never know who else is on this webinar. We keep this open to everyone that wants to attend. And that could include the person that you're up against in a court case currently or in the future. So I would keep your questions as generic as possible, but maybe specific to your circumstances. I won't be able to answer anything based on your governing documents, but I will be able to answer questions based on just the status of Florida law and federal law in this area. So if you are looking for legal representation for your community, including service or assistance animal issues like the ones we'll discuss today, I really hope you'll think of K-Bender Rembam, and you're welcome to reach out directly to me. Jeff will be sending out an email after the class is done with my information, but it's also on this first slide. And I have about an hour to present, an hour-and-a-half long class, including the question and answer session. So if I speak really fast, I'm going to apologize in advance, but we will be supplying the materials in your folder in case I go way too fast. So without further ado, let's get started. So the United States policy is to provide within constitutional limitations. In other words, we're not infringing too much on housing providers' rights. They're trying to provide fair housing throughout the United States. The Department of Justice and the Department of Housing and Urban Development are jointly responsible for enforcing this Federal Fair Housing Act. And that the second F is not what you're thinking, it's federal. That's what I'm thinking too, by the way, because I really don't like when I have to deal with these issues, but frankly, it's something that every community at some point is probably going to have to deal with. So speaking of policies, I do want to—
My favorite F word is food, or free food. But anyway, back to you.
Let's go with that one. Thanks, Jeff. Speaking of policies, I do recommend that each community association have its own written policy prepared by its attorney, identifying how it's going to handle requests by disabled and handicapped individuals. We'll get into some of those definitions of disabled and handicapped in a minute, but handling how those requests for accommodation of your rules, modification to common areas and common elements might be handled by your community. That kind of creates some uniformity. And frankly, it also creates guidelines that can keep your community from getting in trouble with these types of requests. Just a bonus suggestion, there are a couple other policies you should have: covenant enforcement, collection, member speech at meetings, and records inspection requests are the 4 that I recommend almost every community have, in addition to one that deals with these reasonable accommodation, reasonable modification requests. All right, so moving along. The Fair Housing Act prohibits discrimination on several bases. Okay, so this is the federal version. You can't discriminate based on race, color, religion, sex, national origin, family status, which is basically age, or disability. Keep in mind, there are tons of state and local ordinances, including for Florida. So Florida's got a similar requirement that covers pretty much all of the categories that I just defined. And then we've got local ordinances in Palm Beach County. Discrimination is prohibited based also, in addition, keep in mind, to what is already prohibited by federal and Florida law. You also now have to contend with sexual orientation, age, marital status, gender identity or expression. Orlando in particular The municipal code mirrors the FHA, includes sexual orientation and marital status as protected classes. The same is going to be true in Kissimmee and Osceola County. So keep in mind, familial status includes also the presence of children under the age of 18, pregnancy, and some other subject matter that we won't get into in detail here. But just know that there are many, many protected classes, regardless of whether they're listed in the Fair Housing Act or your local administrative or municipal code. So there's a lot that you need to look out for. And when any of these things come around, you're going to want to refer them to counsel. Anytime someone says, I need to have a pet because of a disability, immediately either have that policy in place so you know how to deal with it already that I mentioned earlier, or refer that to counsel so that you don't screw it up and get in a lot of trouble. Okay, speaking of filing potential lawsuits when someone makes a mistake under the Fair Housing Act or Americans with Disabilities Act. In Florida, it's 1 year since the last act of discrimination, meaning if they ask for it again after you say no, and you say no again, that last act is when it starts the running of that 1 year time frame. Now, for those of you who don't know what a statute of limitations is, it's essentially the time frame when you can actually file a lawsuit because you feel you've been wronged. So you can file the lawsuit at any time, but there is an affirmative defense that the other side, the defendant, meaning the association most likely, can argue, well, you know what, they filed this too late, judge, and it should be dismissed. Keep in mind, you can file a lawsuit for anything you want. So you can't keep someone from filing that suit. What you can do is get it dismissed based on the running of the 1 year time frame. Now, in federal court, keep in mind that 1 year shifts up to 2 years from the last act of discrimination. So we've got up to 2 years that, frankly, you're not safe. Okay, so just keep this in mind as a practical matter. A lot of residents will just ask again if they blow that deadline, so to speak, so that it creates a new claim, a new timeline, and a new statute of limitations date. So just be cognizant that, just because someone asks for it again doesn't mean you can automatically say no. Circumstances may have changed, and they may just be basically baiting you into another denial based on the understanding that they have that they're too late to file because of the previous denial. Okay, and when I say file, I mean file a lawsuit, file a complaint with any of the governmental authorities that deal with these issues, etc. Okay, so moving along. There are differences between the United States Code and the CFR, the Code of Federal Regulations. The US Code is basically statutes that's enacted by Congress. The federal regulations are the rules and regulations that are adopted by the individual governmental agencies. Okay, these are all at the federal level. They're enacted by Congress, similar to the Florida statutes when we're talking about the US Code, that authorize the creation, funding, and operation of these codes and committees, just like your declaration does. Your declaration says we can create the Architectural Review Committee, etc. Things of that nature. What they're creating is the entities that create and modify the CFR. We're not going to go into detail. You're welcome to read through any of these slides that we don't go into detail on at a later date, or frankly, later today, because they will be made available to you as soon as this class is done. We talk about the CFR. Part 100 is basically discriminatory conduct under the Fair Housing Act. That's really what we're here to talk about today. Okay, so it's all of these subparts are what is included in that Part 100, which is the pertinent provision of what discriminatory conduct is. The FHA says housing providers can't discriminate against housing applicants or residents because of a disability or the disability of anyone associated with them. In other words, anyone that might come visiting and should be able to have full enjoyment of this property. Okay, the FHA prohibits treating people with disabilities less favorably than others. In other words, you can't discriminate against them. The FHA makes it unlawful for any person to refuse to permit at the expense of the disabled person. That expense portion is important. Okay, reasonable modifications of existing premises. These are changes to your actual common elements. Yes, that is something that you may need to allow. Okay. If that modification may be necessary to afford this disabled person full enjoyment of the premises. So the goal of all of these laws, at least pertaining to what we're talking about today, is to essentially give that disabled or handicapped person the same enjoyment of the property. When I say the property, I mean your common areas, common elements, as anyone without that disability would have. Okay. The FHA also makes it unlawful for any person to refuse to make reasonable accommodations. So accommodations pertain to rules, policies, practices, basically your covenants, rules, and regulations. When that accommodation is necessary to afford the same people an equal opportunity to use and enjoy a dwelling. Okay, that full enjoyment concept isn't saying you have to be nicer or kinder to people with disabilities. What it says is you need to provide them the same right to use and ability to use your facilities. Sometimes that includes allowing them to do things in the community that other people that don't suffer from that disability are not allowed to do. It's not an issue of fairness, even though it's the Fair Housing Act. It's providing fairness to the disabled person, even to the detriment of everyone else. Okay, that's what a reasonable accommodation or a reasonable modification is. So again, accommodation, we're talking about rules. Modification is physically changing your common elements. Okay, so here's some exemptions. Things that the FHA doesn't prohibit. Doesn't prohibit a religious organization from limiting sale, rental, or occupancy of property that it owns or operates to people of the same religion. In other words, these entities are allowed to discriminate. It doesn't say that they can't give preference to those people unless membership is restricted because of another protected class, race, color, or national origin, or the dwelling has a commercial purpose. In other words, if this is a business that's being run just because it happens to be a business run by religious individuals, doesn't mean, that they're exempt. Okay, same thing applies to private clubs. The FHA doesn't prohibit a private club from limiting rental or occupancy to its members or giving preference to those members when the lodging is not open to the public. In other words, only the members can use it. The lodging is incident to the club's primary purpose. In other words, it's not a hotel with club facilities. It's a club that happens to provide lodging, and the lodging is not for a commercial purpose. In other words, it's not purely a money-making scheme, essentially. And when I say scheme, I don't mean a bad one. I just mean that's the purpose. Familial status doesn't apply to discrimination based on familial status with respect to 55 and over or 62 and over communities. So in other words, those communities are allowed as long as you've got the right governing documents, you've got the right percentages of occupancy and ownership. It doesn't prohibit conduct against a person because they have been convicted by any court of the illegal manufacture or distribution of a controlled substance. And it doesn't apply to certain real estate transactions where the owner doesn't own or have any interest in more than 3 single-family houses. In other words, this is not someone who is providing large lodgings. It's someone who happens to own 2 houses and rents one out. And the house is sold or rented without the use of a real estate broker, agent, or salesperson, or the facilities of any person in the business of selling or renting dwellings. This is a vast oversimplification. Reread this a couple times so that it actually sinks in and is understandable. I'd love to go through it in more detail. We just don't have the time today. And you're welcome to reach out to me at any time if you'd like to ask those generic questions. There is a comparison and there are interplays and distinctions between the FHA and the ADA. Okay, the ADA is the Americans with Disabilities Act. These are different laws, but they have similar applications. The ADA generally won't apply to HOAs. That's generally going to be FHA, whereas you may be dealing with both in a condo, or if the FHA provides a public, or the FHA if you're providing public accommodations. So I'm not going to read through this, but these are good things to know. For all intents and purposes, from an association perspective, it really doesn't matter which one you're dealing with, and here's why. The FHA uses the term handicap, the ADA uses the term disability, but those things are both identical. Those words mean exactly the same thing, okay? The definition is drawn almost verbatim in the ADA from the FHA. So let's go through those definitions. The term, and I know I'm going fast, and I'm apologizing again for that. The term handicap means, with respect to any person, a physical or mental impairment that substantially limits one or more life activities, major life activities, a record of that impairment, and being regarded as having that impairment. Handicap doesn't include illegal use of or addiction to controlled substances. Okay, if we hear the word handicap, we know we're talking about the FHA, not the ADA. Okay, use of one or the other doesn't necessarily mean that the owner is asking you for something under one act. Okay, there are no magic words here. when someone's making a request. Just because the applicant uses the word disability doesn't mean their request actually falls under the ADA. Just keep that in mind. When we hear any of these things, we're going to think, oh, they're asking for an accommodation or they're asking for a modification. That's what matters. Physical or mental impairment, we're talking about, and I'm going to skip the actual long worded definition. You're welcome to read through it, but here's the examples that might give clarification. Major life activities, we're talking about functions such as caring for yourself, performing manual labor and tasks, such as picking up your laptop, walking, seeing, hearing, speaking, breathing, learning, and working. These are all things where if you have a disability with respect to one of these items, you are going to be implicating the ADA or FFHA when you make a request, presuming that there's documentation of that disability or it's open and obvious condition. Okay, having a record, that's where we talk about the documentation. Okay, a history or record of or classified as having a mental or physical impairment that substantially limits one or more major life activities. Okay, regarding as having an impairment means it doesn't substantially limit one or more major life activities, but it's treated by someone else as though it did. Having a physical or mental impairment that substantially limits one or more major life activities only because of the attitudes of others towards that impairment. In other words, you can't do things because others see you as lesser than, which is terrible, but it happens. Or you don't have any of the impairments defined in that paragraph, but you're treated by another person as having that impairment. The association cannot ask certain questions. This is the important part. You can't ask if the applicant for a dwelling has a disability, so you can, so to speak, head this off at the pass. That's not an option. You can't say, do you have a disability? Okay. You can ask for documentation to some extent when they request an accommodation, but you can't come out and randomly say, hey, thanks for applying to our community. We'd love to have you. Do you have a disability? That kind of is a red flag. You can't ask if the person intending to reside there or anyone associated with them has a disability, and you can't ask about the nature or severity of the disability. You can ask for a doctor's note. That's about it. And we'll get to whether or not you can even do that. Okay, reasonable accommodations and modifications. We talked about what these are. A person with a disability may need either or both in order to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. Okay, it's unlawful for a person to refuse. And when I say a person, what I mean in your case is the association, whether that's the board, the manager, a director, or anyone that appears to have the authority to speak for the association. Okay, it's illegal, unlawful to refuse to make a reasonable accommodation when the accommodation may be necessary to afford a handicapped person equal opportunity to use and enjoy the dwelling unit, including public and common use areas. In other words, if they can't use their property that they're either buying, renting, or just living in or visiting, and they can't use your common areas, common elements, the same way that everyone without that disability would, you will probably be required under Florida law, federal law, and possibly local law to allow them that opportunity through one of these accommodations or modifications. As to assistance animals in particular, requests are made for reasonable accommodation to an association's pet restrictions. Now, keep in mind, if you don't have pet restrictions, none of this matters because you can't restrict it anyway. So you don't have the right to ask anything. But if you have pet restrictions in place, then the disabled person is allowed to have an assistance animal or a service animal within your community if they request it. Reasonable accommodations for assistance animals. So the FHA doesn't require that an association adopt formal procedures. I suggest you do. Having them may aid the disabled person in making the request. Frankly, more importantly, from my perspective, it also aids the association in addressing the request and also provides records to show that the request received proper consideration. In other words, rather than getting legal guidance on every single one of these inquiries, you're following your procedure that is in writing to make sure that you don't have problems. And you have, frankly, you pay the cost of preparing it and having your attorney look it over one time, and then you're done. You just follow that procedure going forward. The association can make the truth and accuracy of information provided during that process part of the representations made by a tenant under a lease. to the extent the lease requires the truth and accuracy of other material information. In other words, if someone is requesting this assistance animal or service animal and lies in their application to have the animal, you can basically go after them. Now, one thing you can do is go after them to have the animal removed, but also Florida law, and specifically section 413.08 subsection 9, makes it a second-degree misdemeanor to knowingly and willfully misrepresent that you're using a service animal, qualified to use a service animal, or are a trainer of a service animal. Okay, that also says that someone convicted needs to perform 30 hours of community service for an organization that serves individuals with disabilities or for another similar entity at the discretion of the court within the next 6 months. In other words, if it's the mess around and find out law, if someone lies about these things and is found out, then it can be reported to, frankly, police. And it is a second-degree misdemeanor. It can be reported to the FFHA as well, and several other entities such as the Florida Commission on Human Relations, etc. You can't refuse a request because the individual didn't follow the formal procedures. They're just there to make it easier for the association and the individual. So just because they didn't do exactly what they were supposed to do doesn't mean you get to ignore the request. Disabled person isn't entitled to receive a reasonable accommodation unless they request it. This often happens after the animal's already there and they get a violation notice. So keep in mind, once they submit that request, it doesn't have to be made in a specific manner or at a specific time. You just need to go through the process and make sure that you do what you're supposed to do. They don't need to personally make the request. Someone else can do it on their behalf. An individual making the request doesn't need, again, no magic words. They don't need to mention the FHA or use the word reasonable accommodation. If they do that, that's great. It makes it easier to know this is an FHA request. But anything that they put in writing or talk about verbally that would make a reasonable person understand that that is a request for an exception, change, or adjustment to any of your rules because of a disability, that's going to be good enough as a request. It doesn't need to be in writing. There's no magic language that needs to be included. So just keep this in mind. It's the no magic language is very important because there are a lot of things I've seen that the associations that we represent or I've represented in the past didn't realize was an actual request for an accommodation. And it very clearly was, in my opinion. And so the association ends up, frankly, settling for lots of money, and we don't like that. We want everyone to get what they need, and we want everyone to not end up costing all of the other members of the community a lot of money. So that's why I recommend that policy be put in place, and that it be clear that if the request is made in any way that would indicate that this is what someone's requesting, that policy kicks in. So what type of animal is it? There are two types. One is a service animal, one's a support animal, and then the third is it's just a pet. Okay, so keep in mind, service and support animals are not pets. Service and support animals, again, and I'm saying this again slowly because it is crucial, they are not pets. Once you find that it is a service or support animal, they are not subject to all of the pet size, the other restrictions that may be in place other than if they constitute a nuisance, which we'll talk about later. You're going to want to take a look at potentially, if you care enough about this to look, the HUD guidance from 2020 is generally going to clarify the distinction between service and support animals and what the association needs to go through in this procedure. But we're going to go through it in a little more detail. Excuse me, right here. Under the ADA, a service animal is literally just a dog that is actually trained to perform certain tasks for the benefit of an individual with a disability. Okay, they can perform pretty much any task, but it needs to be a dog that is trained in a specific way. Okay, it's a specific action that'll assist the disability. It's not just, well, I took my dog to a trainer. Other species of animals are not service animals for purposes of the ADA. Okay, the only animals that can be a service animal are dogs. Okay, I think there's one or two cases out there that say a miniature horse. I don't know that that applies, but if it's not a dog, chances are it's not a service animal. It might still be a support animal, so don't just ignore it for that purpose. The work must be directly related to the disability. And emotional support, comfort, well-being, and companionship animals are not work or tasks for purposes of a service animal. Okay, so the question.
Alan, before the next slide, real quick, I'm getting this a lot in the chat. For those of you who were not here when I made the announcements at the beginning, okay, the chat is for technical questions only, not for class-related questions. Class-related questions should go into the Q&A, please, and we'll get to as many as we can at the end. And the other thing I announced at the beginning, the copy of the presentation, I'll place the link into the chat once again because if you come in late, you probably don't see it from earlier. It'll also appear as a link on the evaluation, and we'll place the link for the evaluation into the chat towards the end. Back to you, sir.
Thanks, Jeff. So determining whether we have a service animal. Is the animal a dog? If it's yes, proceed to the next question. If no, the answer is no, but it might be another type of assistance animal. Okay, we move on to the next question. Is it readily apparent that the dog's trained to perform work or tasks or for the benefit of an individual with a disability? Here's a perfect example. A guide dog for an individual who's blind or has low vision, a dog that's pulling a wheelchair, it's providing assistance with stability or balance. Okay, so if the answer to this question is yes, you don't need further inquiry. The answer is this is a service animal and any further inquiry is inappropriate. If the answer is no, it's not readily apparent, you can proceed to the next question. And keep in mind, when I say no, don't proceed to the next question, if you proceed to the next question, you are asking too much and violating these Fair Housing and Americans with Disabilities Acts. Okay, now, before we go any further, I want to clarify, violating these acts doesn't just mean that you get in trouble with the government, which it does. It also means that you end up paying all of the other side's attorney's fees and costs if you end up getting sued. And keep in mind, you can't recover your attorney's fees and costs, even if you win that lawsuit, unless the lawsuit was filed in bad faith, meaning there's literally no reasonable basis. I was going to say reasonable reason, but I don't like that. There's no reasonable basis for this individual to have filed a lawsuit. In other words, they are basically filing a fraudulent lawsuit. Not just they're wrong, they're committing fraud. Okay, unless you find that fraud, the association could spend tens of thousands of dollars defending itself and still not recover. This is why it's so important to make sure that you comply with these laws. Okay, so if we're allowed to move on to the next question, is it required because of a disability? If the answer to that is yes, and the work or task is identified, you need to grant the request if it's otherwise reasonable, because the animal is a service animal and it's performing a service. If the answer is no, the animal is not a service animal, so you move on to, is it a support animal? Okay, if at least one action the dog's trained to take is helpful to the disability, it should be considered a service animal and allowed. If there is no specific action identified, the dog shouldn't be a service animal, but then you move on to the next inquiry. Is it a support animal? Okay, so let's move on to that one. If it's not a service animal, it may be a support animal. It's trained or untrained, so there's no training required for a support animal. It does work, perform tasks, provides assistance, or frankly, it's just there for the person. Provides therapeutic emotional support for a disabled person. They don't have to be dogs. It could be any animal. Frankly, I have emotional support chickens next door to my house. I've seen, all of these listed. It could even be a unique animal that's not commonly kept in households. Reptiles other than turtles, barnyard animals, monkeys, kangaroos. I've actually seen an emotional support pony in a condo that was allowed to go up and down the elevators. It could be literally anything unless it's going to cause problems. Now, there are some limitations. Exotic animals don't need to be allowed, but that's going to be a case-by-case analysis that should be performed by your attorney. So let's move on. Here are the questions you can ask when you're talking about establishing a disability for purposes of an emotional support or other support animal. Do they have an observable disability? In other words, they're obviously blind. They're walking with one of those red and white walking sticks. Does the association already have information giving them reason to believe the person's disabled? In other words, there's been a personal injury case. The association was notified of that disability and a judge found there was a disability. Well, yeah, obviously you can't ask anymore. Okay, that it may not be a case involving the association. It could be just that the association has something in its records or something that should be in its records if they were properly maintained that indicates this person might be disabled. Okay, if the answer is yes, proceed to establishing the need If the answer is no, we can't tell that this person's disabled and we have no indication, no observable disability, then we move on to the next question. Has that person requesting the accommodation provided information that reasonably supports that they have the disability? Okay, that's generally going to be documentation. If the answer is yes, proceed to establishing the need for the support animal. Okay, if the answer is no, you have zero indication that this person's actually disabled, you don't need to grant the accommodation. Now, what you're going to want to do is potentially request documentation supporting the alleged disability. Okay. If you have no basis to believe and they can't document that they are disabled, you have no obligation to grant the accommodation. It's not a service animal, which we know because it's not a dog and it's not a disability that we're aware of. And it's not a support animal because we don't know of a disability. So the association at this point is allowed to say no, no thanks, not allowed. Information regarding a disability. This is where we get into the documentation. A determination from some governmental agency, that could be, through a workers' compensation claim, receipt of disability benefits or services, Medicare or supplemental security income for someone under age 65. And I'm not going to go through the litany of what we're talking about here, but there are numerous types of documents that you might receive that show that someone is qualified as having a disability. A determination that the person doesn't have a disability for purposes of a benefit or other program in particular doesn't mean, so if you've got documentation saying the government denied disability benefits, that doesn't mean that for purposes of the ADA and FFHA, you don't still need to go through your analysis. Okay, that is not sufficient to say they don't have a disability, at least for your purposes as an association. Okay. Some types of impairments will almost always be found to impose a substantial limitation on major life activities. In other words, there is a disability. Okay, so there's a ton of these. I'm not going to read them out, but you're welcome to do that once you get the materials. But the obvious ones: deafness, blindness, intellectual disabilities, missing or partially missing limbs, all of these things are going to be open and obvious for the most part. Some of them might not be. You've got bipolar disorder. That might not be so obvious. The person might be what we call a shut-in and not want to leave their house for long periods of time, and then all of a sudden they're partying. I'm not going to do an analysis of any mental illness in particular, but these are all things that could lead to having a disability. So establishing the disability-related need. We've established they have a disability. Now, do they need the accommodation? That's what we're looking at here. Has the person requesting the accommodation provided information which reasonably supports that the animal does work, performs tasks, provides assistance, or provides therapeutic emotional support regarding that disability? Not just that the animal provides support, but that the support pertains to the disability. Okay, if the answer is yes, proceed to the type of animal. If the answer is no, the animal doesn't serve the disability, no accommodation is required. You don't have to require the animal. Okay, the association needs to provide the person requesting a reasonable opportunity to provide information that reasonably supports this question and answer. Okay, you need to say, hey, do you have documentation? And we'll move on to what that is in just a minute. Do you have something that's going to show me that this disability is served by this animal? Okay, so documentation is going to come from a licensed healthcare professional. Unfortunately, that includes some of the ones that are available online, keeping in mind that it is now a misdemeanor in Florida to fraudulently say, I met with this person several times, I know them well, and they suffer from this disability. It can be general to the condition without any specific level of disability, etc. Just they suffer from this disability. It needs to be specific to the individual and the animal. It's not just this person needs an emotional support animal. It's this person needs Peaches in their life for emotional support. Okay, Peaches is the dog. I love Peaches. Peaches is fun to be around. But we want to make sure that this person's entitled to have Peaches, because Peaches is a 150-pound pit bull. Okay, that's a huge dog. I don't know if that dog exists, but the bottom line is we want to make sure that it's not something that's going to be problematic for our community. So a relationship or connection between the disability and the need must be provided by the healthcare professional. particularly where the disability isn't observable. In other words, it's not obvious that there even is a disability, and or that the animal provides emotional support. For non-observable disabilities and animals that provide emotional support, the housing provider can ask for information necessary to conduct an individualized assessment of whether or not it needs to provide the accommodation. The lack of that documentation can be reasonable grounds for denying the requested accommodation. In other words, if you can't come up with a doctor's note, sorry, but we can't tell that this animal serves you and serves your disability. HUD encourages housing providers to direct requesters to the guidance on documenting individuals' needs for assistance animals in housing. That's the 2021 that I referenced earlier, to help the requester and frankly help the association understand what information is sought and to ensure the housing provider gets the information it needs. Okay, again, some websites sell these certificates, registrations. There's a short interview, they pay a fee, that documentation, and HUD says, this is a government entity that says that documentation from the internet is not in itself sufficient to reliably establish that an individual has a non-observable disability or disability-related need. Many legitimate licensed healthcare professionals will do this remotely, including over the internet. That's not a problem, but you need to make sure that the documentation is reliable. If you believe that it's false, you better have a good basis for arguing that, okay? Because saying that we believe the information is false might get you in trouble if you deny the application based on that belief, especially if it's mistaken. One reliable form of documentation is a note from their personal physician that confirms the person's disability and need for an animal, where the provider has individual personal knowledge of this person that needs the assistance. Documents provided to the association go into the official records, but they are generally going to be protected. So these documents that you're getting in connection with someone's request for the animal are going to be maintained in your official records, but they're not subject to disclosure to the members of the community unless the parcel owner says, I'm going to disclose it. So any of this information that's listed in this slide, you are not going to disclose to the members, even if someone requests it. So if someone gets upset that John upstairs has a dog that's barking all the time, that is a barking issue. It is not a should he be able to have the dog issue. Okay, the type of animal. Is the animal commonly kept in households? If the answer is yes, the request should be granted if we've reached this stage, unless an exception exists. The answer is no, the association isn't required to grant the accommodation except in rare circumstances. Okay, we talk about unique and exotic animals. The requester has the substantial burden in these cases where they want a pet tiger, whether that's legal in general or not, I don't know. But if they want an exotic, unique animal, they need to demonstrate a disability-related therapeutic need for that specific type of animal and that specific one. So Tony the tiger is the specific animal that this individual needs to have for these reasons, is what this person needs to be able to show in their doctor's note or their physician's or medical professional's note. The individual should be submitting that information. Allergies say they can't use a dog. They're allergic to dogs, cats, fish, 80 million other things that would be common area pets. Without the animal, the symptoms would be significantly increased. Okay, trained monkey performs tasks for someone with paralysis from a spinal cord injury. If that monkey's been trained to get water, unscrew the cap, insert a straw, and put the bottle in a holder so that this person can actually drink without having someone else with them throughout the day, then that will probably be an animal that they're allowed to have. Now, if the animal poses a direct threat, then the association gets to go through an individualized assessment based on objective evidence that this individual animal poses a threat that can't be reduced or eliminated to an acceptable level through the owner, the resident taking action to control the animal. In other words, keeping it in a secure enclosure, keeping it inside the residence, etc. The association can remove that animal if we have nuisances such as loud noises, intense smells, or actual threat of injury to person or property by that animal that is observable. Then you may be able to have that animal removed. It'll probably need to be replaced with another animal that this person gets to serve that disability. You have to go through an interactive process. We described the questions that you can ask or can't ask. You can't just say, well, the board's not sure, so we're saying no. Okay, you have to make a decision. And before denying that request due to lack of information, you need to ask for more information. Go through this good faith dialogue with the requester called the interactive process. You can't insist on specific types of evidence if the information provided or actually known to the housing provider meets those minimum requirements. This is why I say you can't just ask questions if you already know the answers. A disclosure of details about the diagnosis or severity of a disability or medical records and medical examinations cannot be required. You can require a doctor's note, but not a specific doctor. You can require a doctor's note, but not the severity of the disability that's being served. They have this disability, they suffer from it, and they need this particular animal. That's it. Okay. If you refuse, you need to consider alternative accommodations. If you lawfully say no because we don't think this animal is safe because it's bitten 3 people in the past, this particular animal, you can suggest, well, what about a different dog that is also going to serve the same purpose, is similarly trained, etc. Okay, you can't just say, nope, can't have a service animal because this particular animal is no good. If an alternative accommodation would effectively meet the requester's disability-related needs and is reasonable, you need to grant it. Okay, the association can't require anyone to pay a deposit for an assistance animal or pay an extra fee as a condition of receiving the accommodation, even if that's charged for pets. Again, when we find that there is an assistance or a service animal, that is not a pet. So your pet restrictions don't apply except the nuisance provisions and things of that nature. An association can't ask them to provide access to medical records or medical providers. In other words, you can't force someone to allow you to speak with the actual doctor that wrote the note or the physician that wrote the note, or to provide detailed or extensive information of the physical or mental impairments. And the association also can't unreasonably delay the response. Any undue delay, which could be even a week in responding without writing back saying, hey, we're getting guidance from our counsel. We're not saying no, we just need to evaluate this fully, which is what you should be doing anytime you send it over to counsel, is saying, we're sending this over. We want to make sure that we do this right. We don't want to, say no for the wrong reasons or say yes for the wrong reasons. So we're sending this over to counsel, give us some time. Okay, that's essentially what you want to do here. But that failure to do that or taking too long is deemed a refusal and could be deemed a wrongful refusal. Okay, where can the animal go? Pretty much anywhere that the owner would be allowed to go, although the disabled person is responsible for feeding, maintaining, providing veterinary care, and controlling the animal. They can do that with assistance from other people, but they are responsible for it. Whoever has the animal is responsible for the animal. The association needs to modify or provide an exception to the no pets rule or policy to permit a person with a disability to live with and use the animal in all areas of the premises where people are normally allowed to go, unless, that would impose an undue financial and administrative burden on the association or fundamentally alter the nature of the housing provider's services. Okay, rules governing conduct. Again, any rules that you have that say, you need to have your animals keep everyone safe and not bite, not bark at, not attack anyone. You can still have those rules in place, but it's unclear as to whether it's acceptable for an association to create reasonable rules governing assistance animal conduct that is distinct and separate from regular pet conduct. So, for example, if you have a rule requiring owners of assistance animals to pick up the animal's waste, or a rule prohibiting the presence of the animal within a pool area, you might have issues whether you can enforce that, and if you try to enforce it, whether it is a violation, and frankly, whether someone could file a lawsuit seeking to invalidate the rule without any enforcement done. Even if the rules may apply to support animals, they might not apply to service animals. So keep all these things in mind. If you're going to create rules and regulations, definitely run them by your attorney. Any rules and regulations, by the way, not just these. An assistance animal doesn't count towards the number of allowable pets because they're not pets. Plaintiff can establish a claim for violation of the FFHA under intentional discrimination. Disparate impact, meaning that even if it wasn't intentional, it affects different classes. And when I say classes, I don't mean that in a derogatory context. I mean different races, ages, things of that nature, differently than other races and ages. And it can also be created by failure to allow a reasonable accommodation or modification when one was owed to the person that's requesting one. Now, again, you need to request one to be entitled to it. You can't just say, yeah, I get it now. Venues to bring a complaint. There are several administrative agencies on the federal, state, and local levels. There are courts for judicial determination, or the division, the DBPR. They won't hear fair housing claims. Okay, keep in mind, they're going to be instructed to file a complaint with an administrative agency and provide proof that that filing was done to stay the arbitration. So you need to go through these other administrative agencies before you go to the division. HUD might hold administrative hearings if they find reasonable cause that there is a cause for a violation of the Fair Housing Act. The case is going to go before an administrative law judge within 120 days, or at least it's supposed to, or either party can basically say the federal district court should take over. A HUD or DOJ decision doesn't, not to proceed with an FHA matter, doesn't mean that that private plaintiff can't pursue a lawsuit separate and apart, subject to those statutes of limitations that we mentioned earlier. If the case is heard by the administrative law judge who determines that discrimination occurred, the association can be ordered to pay actual damages, including humiliation, pain, and suffering, provide injunctive or other equitable relief, in other words, to make housing available, allow them to have the accommodation they're asking for, pay the government a civil penalty, which I didn't mention earlier. Maximum penalties are 16 grand for a first violation, 65,000 for a third within 7 years, and pay reasonable attorney's fees and costs. And I promise you, what you consider reasonable is very different from what the judge will consider reasonable. We're talking in the tens of thousands. So we're talking overall about what could be 100 grand for saying, nope, you can't have that dog here. So just be careful with this. Go through counsel every time. Within 20 days of HUD issuing a charge that it found reasonable cause, either party can elect to have the case decided in federal court. Within 30 days thereafter, the Department of Justice will file the suit itself. So keep in mind, the person that's filing this complaint isn't generally paying their attorney's fees and costs unless they file a civil suit separate and apart from a governmental complaint. The government is taking on that responsibility and demanding that you pay back the government's attorney's fees and costs. So don't think that just because someone has no funds available, you're not still going to get hit. And here's the biggie. The court can award punitive damages if the court finds that there's a basis for that. In other words, this was blatant disregard of the owner's rights or the resident's rights. That is very problematic, and the amounts can be enormous. Okay, action by the complainant, pretty much the same thing, just without the governmental penalties. Okay, we're going to skip the cases of interest just for purposes of time constraints, but they are in here that you might want to review what these cases actually found. So I think that these will be helpful as illustrative, but I think that going through a couple minutes of Q&A now that we only have 10 minutes left is probably going to be more helpful. I'm just going to keep going through. This is some FHA case studies. So fortunately, there are 80 slides here. Like I said, this is supposed to be an hour-and-a-half class, in my opinion, at least. And we have an hour, including Q&A. So again, apologies for going a little fast. Apologies for skipping through a lot of this stuff. But the bottom line is I wanted to make sure you got all the important information. And now we can move on, Jeff, to the Q&A portion for just a couple minutes. And then, frankly, I got to go pick up my kids because I wasn't planning on being here today.
Alan, yes, our super sub. So any questions that come in now, please hold off on the Q&A. We're going to go with the ones that are already there for time's sake, and I'm going to skip through, and I apologize if you already addressed some of them because I've been monitoring the chat as well, so I haven't been
no problem.
I didn't have the usual attention that I have to it. Hey, Alan, is there like a sample animal policy that anywhere that somebody can get? Just that was a few people asked that.
I'm not aware of a sample policy that's been created. It is something that we have created for a lot of our clients, but it needs to be specific to condo versus HOA based on what you're going to be subject to, the specifics of your community. So I'd recommend against using some sample policy as what you're going to use. If you find one, then you can run it by your attorney who can then do the review and make sure that it actually works properly for your community. But using a sample policy that you found online could really get the association in trouble because a lot of it may not actually apply to you. So you may be more strict or less strict than the association should be.
Yeah, I'm assuming the person meant like as a template to go ahead and then tweak it, make it your own with your association council.
I'm
Uh,
not aware of one, and I don't think HUD has set forth any kind of proposed policy, because keep in mind, these regulations apply also to hotels. They apply to, apartment complexes. So they're not really going to put out a policy that a community association might use as a sample. There are so many different types of entities and businesses that are subject to these rules that frankly, it would be impractical at best for the government, which any policy that's prepared by the government may not be one you want to use anyway, in my experience. But
Okay.
it's just, it would be entirely impractical for the government to cover every group that is covered by these laws. And also, I will point out that in preparing all of those samples, the government might be inadvertently limiting itself to who these regulations actually can be applied to, because someone could obviously argue, well, there's no form policy out here, so what am I supposed to be relying on? I just presume that because there was no form policy that the government provided, I don't have to comply with this.
Yeah.
It'd be wrong, but at least it's an argument that could be raised that the government frankly probably doesn't want to deal with.
Yeah. Let's go to this one here. If an individual, this is a good one. This one comes up quite a bit, and I remember this back from my my CAM days as well. If an individual has had a pet for 10 years that was not originally either a service animal or an ESA, how can it be legal for a doctor to prescribe that same pet after the fact to allow that pet to now be considered a necessity? I guess if the pet is trainable, does it matter?
I mean, frankly, the pet doesn't have to be trained directly for anything if it's a support animal. It could just be that the pet exists, and when the pet's around, the person doesn't suffer from depression or anxiety because of the pet. They sit and they pet the dog or the cat and they feel better. Again, this could happen at literally any time that this pet is declared an emotional support animal. It's just a matter of whether or not the individual asked for the pet to be declared one. And the other thing I'll point out is, now all of a sudden it's not a pet anymore. It's an emotional support animal, presuming they have the proper documentation and actually made the request.
Okay. This particular question, I think, falls into it's a pet and not an ESA. I'm not quite sure, but can we stop someone from having two pets? One pet needs this. Oh, where they're saying one pet needs the second pet. Again, an emotional support animal for the animal.
I'm not aware of any law that says that an emotional support animal for an animal to have proper enjoyment of the property is required. I'll put it that way.
Okay. Yeah, I haven't heard of that one either.
I've heard of it being asked. I've never heard of any law that says that you actually have to do it, is my answer.
Okay, this one may have been addressed, but I think it garners some repetition here.
Okay.
If your building is a no pet building or a no pet condo and only allows residents, service, or emotional support animals, how should we handle guests arriving with animals? Are we allowed to ask if those animals are service or ESA? Do they have to have the proof with them?
Yeah, I mean, generally speaking, guests are a difficult issue. And when I was at the Orlando Expo, frankly, I get this question every single time I teach this class.
Yeah.
And the answer is there's no easy answer, because, when you're going through this interactive process that I mentioned earlier, it's a process that could take weeks. So to have someone and basically have someone walk onto your property and tell them you have to leave because your support animal is not properly documented, technically, yeah, you could ask for it, but the second that you kick them out, they might not have the same use and enjoyment because of the disability. You might be violating the Fair Housing Act or the Americans with Disabilities Act without knowing it. So the bottom line is you can follow that interactive process, but from a practical perspective, not a legal one, a practical one, I've always taken the position, just let it go. As difficult and as frustrating as that may be, you might be better served letting it go and limiting the time frame when guests can actually be in the property, so that it's not someone that is visiting for 3 weeks and has that dog in the community for 3 weeks that isn't allowed, other than if it's a support or service animal.
All right. Thanks, Elsa. And I think you got that reference. Let it go. You have kids. You should get that reference. All
I,
right. Here's a good one. They're all good ones, but this one in particular, we have residents who are allergic to dogs and they get upset when a dog is in the passenger elevator. Any suggestions on how to deal with this? Can we tell, for instance, ESA owners to ride the service elevator? Would this be reasonable?
that's going to be up to the government and the judge, to be candid. That is, it's not 100% clear, because keep in mind, by telling people you need to be treated disparately, you are treating them disparately. You can't use this with your dog, but let me ask, are you limiting that with pets in the same way? Are you telling everyone with a dog, regardless of whether it's a support animal or not, that they need to use the service elevator?
Okay.
If the answer is no, then you're treating people with a disability even worse, let alone the fact that you're supposed to be giving them, I hate to say it, but more rights than other owners would have. So, I know that it's a difficult issue, and frankly, if you've got people suffering with allergies, maybe have them use the service elevator.
Yeah. I guess it wouldn't hurt maybe to put some kind of a sign saying we request whenever possible to try and do this, if it's not an emergency, blah, 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 and maybe go from there.
Right.
How do you handle, let me see here, pet restrictive condo association that has a Doberman. Okay, so I guess this question is if an association has pet restrictions on size and weight, does that also apply? Can that also apply to ESAs?
Nope.
Okay.
Any pet restriction whatsoever does not apply because it's not a pet.
What about ESAs in common areas, like common areas of the pool, the private beach area, the gym, the on-site restaurant? What about stuff like that?
You're probably going to have to allow the animals. I mean, the pool is the biggest one to me, because having an emotional support animal in the pool is very obviously problematic,
Yeah.
at least in my opinion. And, it may be something you're required to allow. The question is whether or not that would be a potential health hazard that you can regulate. That's one that, frankly, you're going to need guidance from your attorney on. I can't give just generic guidance on that, because it's up to the association, frankly, whether you want to take that risk of someone claiming that they got sick because a dog was in the pool or some other support or service animal was in the pool, versus taking the risk that the person with the support or service animal claims that you're that you're discriminating against them by not allowing them to use the pool because they need their dog. I mean, let's be real. If someone needs the service animal for support, as we mentioned earlier, for purposes of standing upright, that's not going to be necessary in the pool. So keep in mind, they're entitled to use the property in the same way as everyone else would. So if that disability is not served at the pool by having the dog in the pool, then there's definitely not a need for it for that particular person. But this is why I say it's a case-by-case basis. From my perspective, it depends on the actual disability and what is being served by that animal. But then again, the question is whether or not you want to allow any animals in the pool.
Yeah.
The restaurants are less of an issue for me. You may have regulations that govern how pets and support and service animals need to be maintained. But frankly, in my experience, most of the legitimate support and service animals are extremely well behaved because they are trained. Most of the time when they're not, it's because someone got a doctor's note that says they have anxiety and they just want to take their dog everywhere.
Okay. How much you have time for, like one or two more?
Yeah, let's give it maybe 5 more.
Okay.
5 more minutes.
All right, we'll do 5 more minutes. And then before I get to the questions, folks, you're not required to stay for the Q&A part. You've earned your credit. In the chat area, we placed the link. And if you want to hang around after we get to the last few questions here, I'll once again explain the evaluation process if you need that. If you don't need that, click on the link. You can fill out the evaluation. We'll take care of uploading your credits and you're good to go. We thank you for attending. Now we're going to get on to a couple more questions before I go over the evaluation one more time. So this is actually interesting. It's as we get older, we've got to recheck our eyes, get our driver's licenses renewed, get that kind of a thing. So this question, probably know where I'm going with this. With support animals, is an owner required to be reviewed by a board annually, or can is this something that's one and done, or can it be something that needs to be constantly proven?
Good question, and this is another one that comes up most of the time. Maybe I need to just start explaining it during the
Put it in there. Yeah.
It is something where after a reasonable time, some communities say that it's a year, and it would help to have that written into your policy. But I would say a minimum of a year. But after a year or however long your policy dictates, or if you don't have a policy, get one. And if you don't want to get one, a reasonable time, in my opinion, you can request, pardon me, an update and make sure that the person still has the disability. Let's be realistic. If it's that they suffered from blindness a year ago, they're not miraculously cured now, so they might not need that update. But if it's something like anxiety that could get better because they've been in therapy for the last year, then yeah, it might be more reasonable to ask for updated information.
Okay. Can an ESA's animal be banned for bad behavior? Actually, let me rephrase that. Can we ban a guest's ESA animal for bad behavior?
Yes. Same
Okay.
as a member of your community or a tenant in your community. The fact that it's a guest doesn't change the fact that if there is bad behavior, and keep in mind, you'll want to define what bad behavior is. If it's that they barked at someone one time, chances are that's not going to be sufficient to tell someone with an emotional support animal or a service animal, you can't have that animal here. If it's that they tried to bite someone, different story. If it's that they're constantly barking, different story, and you might be able to preclude that animal from being there. And speaking of service animals, I just saw the neighborhood cat walk by the office. We've got 2 or 3 cats that just apparently live in our office complex. So
They
anyway,
say cats choose their owners, not the other way around.
exactly.
I've got new gifts in our driveway literally every single day from our cat that's adopted us. And anyway, we won't get into what those gifts look like once I find them.
Good call.
Now we're not therapists, you or I, although we play it sometimes with our board member clients. The question here is stress, or it makes me calm, a disability of a major life activity. Is that something that justifies an ESA? And I would say that is something that's diagnosed: stress, anxiety, that kind of a thing.
If you have the diagnosed anxiety and the statement by that, it could be a therapist, that that it's just someone licensed to work on medical or mental health.
Right.
Therapist puts in writing, this particular dog will assist with the anxiety that I personally have diagnosed Alan with, then yeah, that's sufficient.
Okay.
Anxiety, stress, whatever you want to call it. I mean, let's be realistic. Stress and anxiety go hand in hand.
Okay. Now there's a few questions here I'm skipping on purpose because people are asking about the statute mentioned in the slides. You're going to have a copy of the slides. We placed the link into the chat. And also, when I go over the evaluation in a couple of moments, I'll show you where you can find the link to get the slides if you missed it when we placed it into the chat earlier. So the statutes that Alan mentions are referenced in the slides, correct?
Yes.
Okay.
If you want to do one last one, and then I'll have to head out.
Yeah, I'm going to do one more here. Do you recommend before exclude? This one is touchy. So I'm going to put you on the spot here. For HOAs with a no pet policy.
Okay.
We're going to play Stump the Attorney. For HOAs with a no pet policy, do you recommend their application form for new owners completely exclude forms for ESA requests? Can you put ownership on the individual to make the request for the accommodation outside of the standard application form?
I would absolutely do exactly what you're suggesting. If you ask the information of everyone, then you are potentially violating the FFHA every single time someone actually does have a disability. You can't ask about it up front until someone requests a reasonable accommodation. So the bottom line is putting in your policy that you're going to ask everyone that tries to be a member or resident in your community, you're going to ask them, do you have a disability? That's one of the things I said earlier. You absolutely can't do that unless and until they say, well, I have a dog. Okay, good for you. We have a no pet policy. So the dog's, oh, but it's a service animal. Ah, there we go. Then you have the obligation to ask the questions or do the evaluation. figure out whether it's open and obvious. So the answer, Jeff, you didn't even realize you threw me a softball there, but the very easy answer is absolutely do not include as part of your policy that you are going to ask everyone across the board whether they have a service or support animal, because that in and of itself is a violation for every single person that suffers a disability. If they don't suffer a disability, okay, the answer is probably going to be no. But if they do, then technically just by asking that, you've potentially violated the FHA. Or
you're making it easy for somebody to get around the issue too, one way or the other. You're giving somebody. You're
inviting people to get that doctor's note is what you're doing.
Is what you're doing, which is not all that different from the scams you see online or the fake stuff you see online. Correct. All right, I know you got to get out of here. You were a super sub. Thanks so much for filling in for Danielle and helping us all out.
Thank you everyone for attending. I hope you all got a lot out of it. Again, Jeff's going to get you my information. It's also on the slides. Feel welcome to reach out for general information, or if you're looking to have a really good law firm represent your attorney, your association versus whoever you may be using now, feel welcome to reach out at any time. Thanks a lot, everyone. Have a great afternoon.